Welcome to Ceasefire, where civics meets civility and engagement meets empowerment. Ceasefire is hosted by former Bernie ISD trustee and owner of the Bernie Bookshop, Dale Adams, and by former Bernie City Council member and local insurance agent, Ron Cisneros. Ready, aim, ceasefire.
Good morning, Kendall County. This is Ceasefire. My name is Dale Adams.
And I'm Ron Cisneros.
And today we're going to get back into our Bill of Rights, and we're going to talk about the Eighth Amendment. And
only about a year after we started the First Amendment, but that's all right.
We're going to try and wrap these up before too long.
What is the Eighth Amendment? And this one, I was really surprised because I thought this is a one-sentence amendment, and I thought, I don't know if we have enough material for a show. I stand corrected. We have a lot of material today, but I'm going to read the Eighth Amendment to you very quickly. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Whatever that means.
Whatever that means.
Well, the interesting thing about this one is it is so vague. It doesn't define any limits or any actual excessiveness.
Mm-mm.
And so it's actually structured to follow whatever the society considers acceptable, which I thought was kind of neat. They weren't trying to impose anything, but it revolved around what they considered excessive. And I'm going to read you what the punishment for treason was in Britain. It's actually interesting. Recorded by William Blackstone. The British penalty for high treason was to be drawn to the gallows and not be carried or walk, that he be hanged by the neck and then cut down alive, that his entrails shall be taken out and burned while he is yet alive, that his head be cut off, that his body be divided into 4 parts, that his head and quarters be at the king's disposal. That was in law. That was that societal norm. That's unbelievable by today's standards. And actually, I think our forefathers considered that excessive, which is why they put this. But when we talk about excessiveness, we got to realize we've come a long ways from what was considered normal.
Now, which part of that was the excessive part? Oh, sorry, just kidding.
They weren't allowed to walk to the gallows. They had to be dragged. I was like, okay.
Oh, that was the part, but everything else.
That's right. The rest was, yeah.
My goodness, yeah, I found something similar. Well, first off, I want to talk about the founders for a moment. This wasn't their idea. This was actually in the English Bill of Rights of 1689, and all of that speaks to cruel and unusual punishment, and it goes back to King James II and a judge named George Jeffreys and their brutal punishments that they imposed on political opponents. And all of that is what you had just mentioned, and the English Parliament decided, we're done with that. We want to put an end to that. And so then our founding fathers put that into our Constitution as well.
Yeah, which shows that our Constitution has roots that go far back in English culture, in Roman and Greek, and it's coming together the way it did was unique, but it had roots all over the place. Yeah. You can break this up actually into 3 parts. And the excessive bail, the excessive fines, which are different, and cruel and unusual punishments. Bail is interesting because it's sort of a subjective thing, because the point of the bail is to give you enough skin in the game that you're going to come back to court if they let you out, which is different for everybody. And that's why bail is different for different people. I mean, some people say, oh, you shouldn't charge that much bail because you didn't charge it that much to this other person who's poor. But the point is to get you to feel that you have to come back to court. And so the bail concept is interesting, especially the movement now to have no bail and just let people wander off and say, oh, please come back. And they will. And they won't. You know, they won't.
It's a very subjective idea. Like, what kind of bail would you have for Elon Musk?
Right. Exactly. Man could go off and buy a continent, you know.
He could go buy an island and, all right.
Yeah.
Do what you want. Yeah, that one was interesting. And I'll confess, I don't have a whole lot on that. I've spent more of my time focused on trying to come up with what cruel and unusual means. Because that's, as you pointed out earlier, that seems to change with time.
Yep. Very vague, very subjective.
Yeah. Well, like the idea of capital punishment for children.
Yeah.
Which I think, I may be wrong, but I think most people would agree that that's not good, and we shouldn't do that. But there's nothing in the Constitution that prohibits that either.
But the interesting thing I found when I was reading about this is that the issue of capital punishment that we have today was going on then. There were people at that time that said, you can't kill people for any reason because that's just wrong. And, you know, today we go back and forth, but we've been going back and forth for 200, 300 years about that concept. So that's not a new argument, even though some people today like to think, oh, well, we're not as bad as they were then. Back then, they just killed people for the heck of it.
Right. You know, there's an interesting movement on the pro-life side that's also anti-death penalty. And there are liberals who are opposed to abortion for the same reason that they're opposed to the death penalty. So they view that all life is sacred, and you can't take any life for any reason.
And I think there's a really good argument for that. I'm not going to say I'm anti-death penalty, though, but I do believe that argument is valid. Yeah. I really do.
Well, I think you and I have discussed this before, and I generally am opposed to the death penalty. Now, then somebody like Timothy McVeigh comes around, and I think, oh, gosh, how can I be opposed to the death penalty when there's somebody as sinister as Timothy McVeigh who killed children?
Yeah.
And then I soften on my views on the death penalty. Yeah. But for the most part, I'm opposed.
Yeah. We maybe should discuss that, because I think we might have different views on that.
I know we do. Because we'll need somebody to mediate. So, you know, because the show is called Ceasefire. So, you know, I don't want to come to blows.
No, I don't either.
Talking about cruel and unusual punishment, I want to talk about some landmark Supreme Court cases that discuss that. And the very first one is from 1878, and it's Wilkerson v. Utah. And this was a case about the firing squads and whether or not they were cruel and unusual. The Supreme Court decided that it wasn't. I don't have all the details on it, but they just said, no, firing squad's fine. But they did point out some things that were not: drawing and quartering, disembowelment, and burning alive.
I'm actually good with that.
I am too, yeah. So I think what we can gather from that is that instantaneous death is fine. You know, drawn out death is not.
Right, which I think gets to the purpose of that particular death penalty, is that you're trying to end that life. You're not necessarily trying to torment somebody or get satisfaction from that torment, which I think is what the whole gallows and the disembowelment was about: getting satisfaction, personal satisfaction on the part of the audience from seeing something terrible happen.
Right.
Whereas a firing line or an injection or something like that, that's just ending that life, which was just so evil that needed to be removed.
Right. So here's another one. This is in 1910, and this doesn't have to do with death at all. So this is just excessive punishments. This is a case of a government official in the Philippines. So I guess this is back at the time when it was a U.S. territory.
Right, yeah.
And he falsified some documents, and for that he got 15 years in chains. 15 years in chains.
Wow, that's rough.
For falsified documents, right? And so the Supreme Court threw that out and basically said that was too extreme.
I guess they didn't have... those driver's licenses that said you were already 21 back then. We'd have a lot of teenagers in chains.
Oh my gosh. Not me, of course.
Me neither.
This is another one. This is Trop versus Dulles. This is 1958. A soldier deserted during World War II, and the government revoked his citizenship for desertion. And the court rules you cannot make someone stateless. Now, this is an important case because this is back when Earl Warren was the Chief Justice, and he wrote a line with a phrase, "the evolving standards of decency that mark the progress of a maturing society." And I thought about that for a moment, because this goes back to what you touched on very early on in the show. And I think you were reading from Blackstone, I believe, and talking about how our idea of what's acceptable has evolved.
Yeah.
And I don't want to get off into a bunny trail, but that got me thinking about the big Scalia and Brennan debate about whether or not the Constitution is living and breathing, or whether it's, as Scalia said, dead, 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 you know. And so how do we interpret what's cruel and unusual over time, you know, if the Constitution is, as Scalia says, just dead, dead, dead?
Well, but the Constitution allows for that growth and change. So that particular discussion isn't about the Constitution at all, but how we grow and change in what we consider cruel and unusual requires us to understand that different times do have different standards. One thing I see a lot today is people look back and say, oh, back in that day, that guy spanked his son, you know, back in 1850. That was terrible. Well, no, I'm sorry. That was part of acceptable behavior back then. You need to understand that that means it was acceptable. And we do things today that maybe 100 years from now people will say are unacceptable. But we need to understand that what is acceptable at that particular time needs to be considered acceptable for that particular time.
Yeah.
And we can't grow and change and decide that we want to be different if we can't accept that each time frame is allowed to set its own standards.
Right. I think that's interesting because it goes back to something we've talked about multiple times, where we take historical people out of the context of their time. And,
exactly.
You know, I think we talked about Robert E. Lee just a couple of months ago, you know, or when we take the ancient Greeks out of their context, right? And
make them American.
Make them American, right? And so we say, hey, you can't do that. That was wrong. These people were terrible people. And it's like, no, they weren't bad people in their time. They're bad people by our standards today.
Right.
Or we think that what they did was bad, but they weren't really bad people.
Right.
Not in their time.
Yeah. It's hard to really accept that because we all have our things inside that we do think is right and wrong. And it's hard to sort of say that might be a little bit malleable over time, you know? And so that's a tough one.
Yeah.
But we need to try and do it. With that, we are going to take a quick break. This is Ceasefire with Dale and Ron, and we'll be right back. Bernie has its own bookshop. In fact, it's called the Bernie Bookshop. Hi, I'm Dale Adams, inviting you to get lost. Get lost in a good book in our relaxed and casual atmosphere. We have a wide and eclectic selection in the Bernie Bookshop, and we pride ourselves on finding what you're looking for. We do author meet and greets, host writing workshops, and can connect you with a good book club. And your young ones will absolutely love our kids section at the Bernie Bookshop. And while we want you to get lost, we're easy to find, as we're in the heart of Bernie at the back of the Richter Tavern building. We are the Bernie Bookshop. Welcome back. This is Ceasefire with Dale and Ron. We're talking about the Eighth Amendment. We've been going over some cruel and unusual punishment. And where do we go from there? Well,
let's talk about a point in time, 1972, when the Supreme Court said that the death penalty was no longer legal. And this is in Furman v. Georgia. This is interesting because they're going to come back 4 years later and say, no, it is constitutional. The crux of this is that they felt that the way that capital punishment was assessed by the states or by the individual counties within a state was arbitrary. Mm-hmm. So for about 4 years in this country, there was no capital punishment. It was deemed illegal, unconstitutional. Yeah. I don't know that there was a change of heart. I was a little kid back then, so I can't tell you what people were thinking. But 4 years later, we come back, and in Gregg v. Georgia, the states had rewritten their laws, and capital punishment was reinstated. Now, I read somewhere in a history book not too long ago some criticism about this case, that it was more a political decision than a constitutional decision. This was the court trying to appease the populace. I don't know how true that is. Again,
but values about punishment, like we said, is vague and changes over time. That's based on cultural acceptance of things. And the court had tried to say that the death penalty is no longer acceptable in our culture,
right? But
it was wrong. And it had to come back because of political pressure from the populace, who are the embodiment of our culture. to return it.
Right. Well, to that point, so here's another case. I always get surprised when I look up these cases and I find out they're more modern than I would have expected.
Yeah.
I was like, what? It took us that long to figure this out? But this is a case, Atkins v. Virginia. This is from 2002. Execution of intellectually disabled defendants is deemed unconstitutional. And this goes back to Warren's evolving standards of decency, right?
Exactly.
Again, 2002, holy smoke. So that means that up to 2001, we could take a intellectually challenged person and execute them for a heinous crime.
Which actually, that doesn't surprise me, because I think historically, if you go back long term, historically, intellectually challenged people were done away with quite regularly, I think. As children or as they grew up, or at least they were abandoned to their own devices in the wilderness kind of thing. I think there was a fair bit of that. I think it took a long time for humans to say, okay, we're going to take those people who need our support as a society to survive, to actually give them that support.
I don't want to get off topic here, but I'm thinking about, and I can't remember his name, but the individual who murdered Charlie Kirk, or Mangione, the guy that killed the UHC CEO. Yeah, imagine a lot of these defendants are going to claim insanity. And so how much of this ties into that particular case? Because I know some people get angry and they say, no, those folks aren't crazy. They're acting crazy to get away from the capital punishment. But then there were people who were legitimately intellectually challenged that probably had no understanding of their criminal actions.
Yeah. I think there's a difference between mental capacity and insanity, because a lot of these insanity pleas are temporary insanity, which are sort of like crimes of passion. Let's see, a friend of mine was just telling me about the first time the insanity plea worked was in early 1800s, and it was when who wrote the Star Spangled Banner?
Key.
Who?
Francis Bacon
Francis Key. His son was shot by a man whose the son was having an affair with, and he claimed temporary insanity because the guy was having an affair with his wife, and he just went nuts and shot him, and he got off on it. And so the temporary insanity to me has nothing to do with mental capacity, even though it's sort of framed that way. I prefer to think of it as a crime of passion, which is a problem too. If you can't control your own passions, then maybe you should be put away. But I think it's important to distinguish between mental capacity, permanent mental capacity, and temporary insanity, which is what I think most of these insanity pleas are all about.
Yeah.
And I got to admit, I don't buy most of them.
I don't either.
Yeah.
So moving on, Roper v. Simmons, 2005, execution of juveniles. Court says it's unconstitutional. And again, as I pointed out earlier, there's nothing in the Constitution about minimum age for capital punishment. But modern society says, hey, that's not cool. You can't do that.
Yeah.
And then you think about, I have to bring up a sensitive subject here, but all of the school shootings.
Yeah.
And
some evil young people.
You're right.
Yeah.
Right.
It's possible to be young and evil. So once again, I agree that's a really tough area, but I think there are cases that would justify it.
Yeah. Well, I'm going to think back about my own childhood.
You aren't that bad.
No, I wasn't bad, but I was immature. I was very immature as a high schooler, but fully capable of knowing right from wrong.
Yes.
I just happened to choose wrong a lot, but fully understood it. And I think if you had a child who is 8 years old, I think even they have an innate sense of right and wrong, but maybe not the full understanding of a 16-year-old.
Right. Yeah.
And a 16-year-old doesn't have the full understanding of a 26-year-old. We can go on and on and on, but at what point then is somebody capable of saying, hey, that's just outright evil. I cannot do that.
Well, and I would take that a step forward and say, at what point does that, whatever wrong that they've committed, leave the family and needs to be dealt with by society. So if a little toddler goes in there and grabs a bag of gum in the store and runs off, Dad will come in and take care of it and return the bag and stuff like that. But that little toddler does not need to be arrested. Mm-hmm. But I think that whole concept is a graduated thing. And I think by the time you're 12, it varies for everybody. It's going to be a case-by-case issue if you're addressing this. But pretty early on, the taking of life is understood to be an absolute no. And I think some pretty young people can understand that and need to be held accountable. And the taking of life or severe damage of life or anything like that is not something a family can take care of. A dad can't take the kid behind the woodshed and give him a beating because he shot somebody in school.
Right.
It's not going to be a family thing. It's going to be a society thing.
There was a story I was reading last year sometime about a young child under the age of 12 that killed a sibling, 7 or 8, somewhere in there, and intentionally did it. Right? And I think about that, and maybe this is wrong, but there has to be something defective mentally in a child. Because as I said earlier, you're born with this sense of right and wrong, I believe. You know from the outset that there are some things you don't do. Now, there are some things you learn not to do, like sticking your finger in a light socket, right? And
eventually, yeah.
Yeah, eventually. And then there are things that like you have this sense of justice, a sense of fairness, of equality. But
some people aren't born with that.
Right.
And we call those sociopaths.
Right.
But we don't really know that they're sociopaths in the bad sense until they're older. But even as children, they may have that tendency or that lack of moral compass or whatever you want to call it, and it may show in early ways. In this child that you're talking about, it sounds to me, and I don't know the specifics, didn't have a moral compass of any sort.
Yeah. I'm going to cover one more because we're running low on time. Kennedy v. Louisiana, 2008. This is where Louisiana authorized the death penalty for child rape where the child survived. The court struck it down and has basically limited the death penalty to homicide and crimes against the state. Now, I think if somebody commits treason, that's terrible, right? But raping a child, I think that's greater than crimes against the state. I think the general population in Texas would agree with me on that.
But I think they always want to keep that one in their back pocket. Treason is something that governments are always considering to be the worst of the worst because it's against them.
Right.
So they're never going to accept that, well, treason isn't that bad or this treason's not so bad.
Right.
They want to be able to punish to the max any kind of treason.
And that's interesting because when you look at our Bill of Rights, they're intended to empower the individual citizen, not the government.
Yeah.
So this notion that, well, you can't ever be treasonous. Well, what if the government is in itself corrupt and treasonous against our rights, right?
Yeah.
So,
yeah, there's a conversation.
Yeah.
Okay, well, I'm going to bring up a book I got, and this is called Mindhunter by John Douglas and Mark Olshaker. And Mr. Douglas was in the Investigative Support Unit, a special agent in the FBI, and he worked with tracking down serial killers. And basically, they tried to analyze their minds and how they think so that they could track them down and find out who that was and figure it out. So kind of a gory thing. There's a memoir by him talking about all the different cases he worked in and the people he tracked down and whatnot. So kind of neat book. We got it at the Bernie Bookshop.
I don't understand why anybody would want to kill cereal. I love cereal. Cinnamon Life, Apple Jacks. Fruit Loops.
Well, you're not up on the current nutritional standards, which say that cereal's bad for you.
Oh,
so there you
cereal's
go.
Great. Cereal makes a great dinner. I love cereal.
Okay, that's an ad plug for somebody, I guess. I don't know. Okay, that's going to wrap us up for Ceasefire with Dale and Ron. Thank you for listening to us. And if you missed any of it, you can always go to BernieRadio.com, listen to our podcast or any of the other great podcasts they've got there. We'll see you next week.